The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. 3 cases are scheduled to be submitted this afternoon. Those cases are Dakota, Minnesota and Eastern Railroad versus Iowa District Court for Louisa County. Second case is Central Bank and Real Estate Owned LLC versus Timothy C. Hogan and others. And the final case is State of Iowa versus Jared Majors. We'll now hear the arguments in the Dakota, Minnesota case. Ms. Finley.
May it please the court and counsel. The issue presented is whether this court should vacate the district court's contempt ruling finding that Dakota, Minnesota was in contempt of court for willfully violating a 1977 judgment that required Rock Island Railroad to rebuild an earth dike near a bridge by Whiskey Creek to prevent the flooding of upstream properties. The earth dike was Chicago Rock Island did begin reconstruction of that earth dike, but it immediately washed out. And attempts were made again to rebuild the dike in 1984 pursuant to a contempt order. And once again, that dike immediately failed. After the earth dike's collapse in the mid-1980s, no action was taken to rebuild the dike or to enforce the 1977 judgment until the Drainage District brought this action for contempt against the property's current owner, Dakota, Minnesota. The Drainage District argues that Dakota, Minnesota has an obligation to maintain the Whiskey Creek property. And Dakota, Minnesota does not dispute that it may eventually be found to have some obligation or duty with respect to that property, or some duties with respect to the water flow across or around its bridge and its property. The purpose of this appeal and the fundamental issue is that the nature and scope of those duties and obligations cannot be properly defined in a contempt action brought to enforce the 1977 judgment. And this is especially true because merely enforcing the terms of the 1977 judgment have been demonstrated the remedies that were ordered in that judgment have been demonstrated not to solve the problems the judgment was intended to address. The dike has failed twice since the entry of that judgment, and water on adjacent properties continues to be an issue. And the most likely reason for those ongoing problems is the 1977 judgment, as well as some previous court orders, had failed to take into consideration or adequately acknowledge the geographic, topographic, engineering realities, and especially to the extent that the 1977 action was originally brought to enjoin a downstream landowner from building a dam and sending the waters back up.
Does that dam still exist on the Downer property?
I believe it does.
Does the record, I should ask, does the record show? I couldn't find any indication about that.
We will find out, I'm sure, when, based on this. I did not see anything in the record to show that it did not still exist or that it had been removed. But whether that dam, whatever shape it's still in, the district, the adjacent landowners, and the railroad all acknowledge that water has not been flowing under this bridge for over 100 years. So the history and the unrefuted expert testimony presented by Dakota, Minnesota show that something other than a reconstruction of the earth dike as ordered in the 1977 judgment is required to address the issue. And all of the necessary parties, including the adjacent landowners, need to be involved in that resolution, whether it's through voluntary informal negotiations and agreements, or whether it needs to be through a direct action.
ask you a question about a provision in the 1977 injunction that I didn't see discussed much in the briefing. And I'm talking about paragraph 4. This one says, the plaintiffs are entitled, I'll wait till you get it. Yeah, page 345 of the appendix. It says in paragraph 4, the plaintiffs are entitled to a prescriptive easement for the flow of Whiskey Creek under Bridge 110 of the Chicago, Rock Island, and Pacific Railroad Company. Now, I understand their position that, number one, this injunction wasn't permanent, it's expired, and number two, it's not binding on your client, which is not a corporate successor to that 1977 railroad. But this prescriptive easement language to me sounds like something that could potentially be permanent and that could also run with the land. Am I misreading it? Help me out.
Well, and that is what the court said. Unfortunately, it doesn't reflect the reality. I mean, it might be entitled to the easement, but what was ordered, the remedy that was ordered, which was the construction of the earth dike, does not allow for the water to run under. I think Chicago, Rock Island first sought an order from the district court that the water would not run under that land in 1913, saying that we can't make it run under that land. And so the water has been flowing to the north side of the bridge, or there's evidence that it has been, for several years. So, I mean, I don't, those are all rights that need to be litigated and determined.
But you want us to draw a distinction, and I think correctly so, between sort of the ultimate merits. What are the obligations of the railroad under water and land use law and any contracts and things like that, and contempt, which requires a willful violation of a court order. Doesn't this language indicate that, at least arguably, there was some kind of court order in effect that granted an easement? Now, I recognize it's to the plaintiffs from 1977, and the district was a party, but it wasn't a plaintiff in 1977. But doesn't this language maybe help them out a little bit?
Well, I mean, it certainly is what they're relying on and what the district court relied on to say that there is a permanent injunction running indefinitely with this land. However, this court in A Man of Society said, you can't do that. Whether you look at this as a judgment, it expired 20 years after its entry under the statute of limitations in 614.16, or if you look at it as, and the only way they get the easement is enforcement of an injunction. And more importantly, this is a judgment. The only way that a party can be aware that it has an obligation is by either checking the clerk of the district court to see, is there a judgment, and has there been a judgment on file in the last 20 years, or to go to the county recorder's office and see if there's any restrictions on the land use. And basically that has to be, I think, 21 years or redone. There'd be no way for
wouldn't there be another way for your client to know about that? That is, just ride the track and see that the railroad bed is obstructing the movement of the water to the southeast, and automatically have an understanding that, hey, we can't obstruct the flow toward the slough as a consequence of our railroad bed, so we know we've got to take care of that.
Well, the problem is that the water doesn't, the evidence shows that the water has not been flowing under that slough for over 100 years. And the expert testimony presented by the Dakota, Minnesota, and the drainage district presented no expert testimony, said that fixing this and allowing this water to flow through might very well have negative impacts on other landowners. It would probably not fix the problem. So again, the issue isn't whether the railroad may have some statutory or general obligation. It's whether it willfully violated a 1977 order that wasn't recorded anywhere.
Would this easement that Justice Mansfield talked about be subject to the stale use statute?
Yeah, our position is that one of two statutes of limitations, or both, operate to bar this contempt action. Either, as I mentioned, the 614.19, which requires any action on a judgment to be brought. And before I get to the stale use, well, I'll do stale use first. If that does not apply, then you would look at the stale use statute of limitation in 614.24, which requires, if you are going to restrict land use, you have to have that recorded, and you have to bring the action within 21 years of it being recorded.
You have to renew it within 20 years plus some time based on when it was put on.
Right. And to circle back to the 614.16, because I really think the analysis can stop there. That statute of limitation says any action on a judgment is barred within 20 years if it's not brought within 20 years of the filing of the judgment. The document upon which this entire contempt action is based is called judgment entry. It was entered on February 2nd, 1977. So it will be 40 years old on February 2nd, 2017.
Ask you about that stale use statute. It says, no action based upon any claim arising or existing by reason of the provisions of any deed or conveyance or contract or will reserving or providing for any reversion, reverted interests, use restrictions in and to the land therein described. So which are we talking about? Are we talking about a deed, a conveyance, a contract, or a will?
I would say that it was a conveyance, because if it's not treated as a judgment, if this document is not treated as a judgment for the purposes of 614.16, it certainly conveyed important rights and obligations to the affected landowners. And again, you have two places to go. You either look for a judgment in the clerk, or you go to the county recorder. And the Stale Uses Act, as you know, was intended, the policy behind it, it's to be construed broadly and liberally to promote the very important public policy of restricting the amount of time you have to have for a title search. And one last thing, I'm sorry to keep harping on 614.16, but you know, the district's argument, and I think the court was persuaded by it, was, well, it doesn't apply to permanent injunctions. And you know, it says any action except actions for child support, spousal support, and the division of marital property. It doesn't say any any action on a judgment unless that judgment contains a permanent injunction. So yes, it's Dakota, Minnesota's position that this action was time-barred and unenforceable under both 614.19 and the Stale Use Act of 614.24. Oh my gosh. The district court found that it was Hawkeye was looked at the Hawkeye land case to find that we were successor in interest. In that case, this court looked, it specifically said, to determine whether a successor in interest, a party is a successor in interest, you have to look at the context and the interests of the parties and the applicable law and the policy behind the applicable law. And it made sense there where the successor in interest was a land company who had purchased the rights to grant an easement against railroad property, that they would be a successor in interest to the railroad for the purpose of a pay-as-you-go statute to allow those easements to be, to be easier for utility companies to obtain. Here, there is no the Iowa law is pretty clear that you can't hold a subsequent purchaser of property liable or find that a permanent injunction entered against another party in a prior action unless they were either named or otherwise identified. And here, you know, the injunction doesn't say all railroads or any subsequent purchaser. It just says Chicago, Rock Island. And even if it is enforceable, there's really no basis for finding that we willfully violated this. We continue to have real questions about whether this is enforceable against Dakota, Minnesota as a subsequent purchaser. And to find us in contempt in the same order that you found that we had a duty is really denies the railroad its opportunity to litigate whether or not it was enforceable.
You've asserted, I'm sorry, may I ask one more? You've asserted both a standing argument and a constitutional argument, and there's a dispute about whether there's standing, whether you asserted the constitutional argument in the district court. You want to comment on that?
Yeah, the standing issue is that the original judgment in 77 wasn't ordered. I'll try to go fast. Wasn't ordered for the benefit of the district. It was entered for the benefit of the upstream landowners. That was addressed, and we've cited it in our reply brief. It was in the motion to dismiss, the reply, and then trial counsel did argue it in front of the district court. And then with respect to the due process arguments, I mean, the argument is just what I made, which is you can't willfully find somebody in quasi-criminal contempt for violating an order that there's a good faith basis to.
So it was the substance of your argument, you just didn't use the words due process.
With respect to that, we didn't use the magical due process, but clearly the issue was litigated and the trial court ruled on it, and it's still, you know. Whether you call it due process or you say you can't find a basis for willfulness doesn't really matter. It amounts to the same. You get to the same place. My time's up. Sorry.
Thank you, Ms. Finley. Mr. Power.
May it please the court. Counsel, I do want to comment very briefly on two things that the court's concerned about, and I've just heard the question was asked, why is the water flowing under the bridge? Is it not flowing under the bridge and hasn't flowed under the bridge for 40 plus years? I like to have graphic exhibits, and so I brought one along with me today. I'm going to try and explain to the court, because if you read these old decisions, they're not archaic language, but they're really hard to follow. So I'm going to make it as simple as I can of what's happening here. Okay, this is Exhibit 47. The railroad line is running from the northeast to the southwest in this direction. This meandering thing here is the Muscatine Slough. That's the main drainage ditch for the district that's involved in this lawsuit. The creek, the Whiskey Creek or Whiskey Hollow Creek that we're talking about, actually originates over on the left side, but comes down out of the bluff, runs in this location down to the levee right-of-way, down the right-of-way, and then turns, or is supposed to turn, and go under the bridge, and proceeds down through a channel here and empties in the Muscatine Slough down here. The problem is, very simply, that this creek runs into this big main slough, brings all kinds of dirt, debris, blocks it up. The upstream farmers in this location have the water back up onto their properties, and they lose their crops. The drainage district is there to provide them with drainage. They can't do it because this little line right here is where the slough is blocked because of the flow of water in the Muscatine Slough. That's it in a nutshell. So why won't the water run under the bridge? Because the railroad hasn't maintained the bridge for 40 plus years. In the record of this case are our Exhibit 7, which show from approximately 1930, when aerial photographs first became available, up until 1970, when we had the second lawsuit over this case, the water was flowing under the bridge, down to the south, and into Muscatine Slough where it's supposed to. The reason it won't run there is because the railroad hasn't maintained the bridge.
Let me ask you a question. You know, I assume what happened in a few years ago is the Dakota Railroad purchased these assets of this other railroad, and assume that they're a normal, careful, cautious corporate purchaser. They're going to check with the county recorder, and they're going to potentially look for judgments. But if you're right, they would have to run a judgment search potentially indefinitely back to find out if there's some obligation that they have to perform if they buy this railroad line. Isn't that right?
Well, two answers, I think. One is they might look in the clerk's office, in the Louisa County Clerk's office, because that's where the injunction was of record, a matter of record. The second,
But they'd have to go well back, I mean, in this case, because well beyond the 20-year statutory period, correct?
I'd have to go back to 1984, when Judge Boehner, the district court judge, found this was Rock Island Railroad in contempt. Yes, they'd have to go back to 84. True. The second point was raised over here is, gosh, if I bought this railroad and I was going up and down it, and railroads are very persnickety on keeping their rails and their facilities in good order, I would come to this bridge and I would ask myself, why is this bridge here? There's nothing running under it. So did the railroad do their due diligence when they purchased the property, whenever they did? I think they had an obligation to look there. Also, it's replete in the record that when the district first got involved in this matter that's resulted in this suit, we notified the railroad repeatedly of the court decrees, of the Supreme Court decisions, and nothing happened. We started in 2008.
But that assumes you had a right to enforce the judgment in the first place, right?
That's correct, Your Honor. That is correct.
How do you get around the statute of limitations for judgments, 614.19?
To me, that's a property. I do real estate law. That's a property concept. It's, the appellant keeps styling this as a judgment. It's not a judgment. It's an injunction. It's a different animal. I don't think it's a property law issue at all.
What's your view on the prescriptive easement point that Justice Mansfield raised earlier?
Good point.
Is this an
Yeah.
easement or not?
But even if it is, you can't get a prescriptive easement against a public entity, black letter law in Iowa. You can have an action that you can claim prescriptive easement against any public body in the state of Iowa, and it won't stick. There is no such thing.
It's the other way around. The language says there's an easement against the railroad, which is not a public entity, right?
Correct. And it was, the easement was in favor of the landowner, then landowner to the north. You're correct. You're correct about that.
Well, let's assume there's a room to debate the legal issue, and even if you ultimately win your points, how do you get around the fine? How do you establish willfulness if they believe they had a good faith argument that the easement or injunction was not enforceable against that railroad?
I think the willfulness goes back to, as Judge Schilling of the district court found, that in 2008 they were clearly on notice because I wrote a series of letters to responsible people within the railroad, and nothing happened for 5 years until we had to finally bring suit. The stuff that I sent to them were the cases, were the 1911 cases, was the 1913 opinion of this court, was the 1977 injunction from Judge Cahill. They were well aware of this. They were well notified that this was out there and did nothing.
Counsel, as
They were.
a practical matter, having at least speed read through the correspondence, the conversations, the communications going between your client and the railroad over the last several years, it seems to me that at least the expert opinion, the consultants, the engineering folks, believe that a solution of this problem is pretty massive in scope, and will entail not just reconstructing the berm that you complain about, but also significant work south and east of the bridge,
Yes.
on land owned by people who aren't even party to this case. Isn't the better option here really to get all of those folks at the table rather than just the district and the railroad to solve this problem?
In the record, and I may not have put it in my brief, but I think I did. And in Judge Cahill's opinion back in 1977, he pointed out the evidence showed there was a drainage ditch running south and east from the bridge, running through this farmer's property that had been dredged at least twice by the Rock Island Railroad. Now, that's a long time ago, and I looked to the land records and tried to find something that would say there was an established ditch there, and I never found it. It has a name, and the opinion is called the Smalley Ditch. So I know it existed.
Well, I saw references to dredging in 1948, again in 60, and again in 73.
Yes.
But couldn't that have been just, rather than the legal obligation of the railroad then owning the bridge, just an effort to try to work this out? And so can we really conclude from the fact that there was dredging south and east of the bridge on these prior occasions that there's a legal obligation to do that by this defendant?
But if I recall the opinion of this court done in 1913, this court said that the railroad was under an obligation to provide a means of entrance or exit for the water to go south under the bridge.
Even beyond the railroad right-of-way, though, to go off on somebody else's land and be dredging and creating or maintaining a drainage ditch all the way to the slough?
I would maintain that is the railroad's obligation, to let it escape. It can't escape because it doesn't have anywhere to go. I will point out, in the record as well, and if you look at the exhibits 7 through 10, at some point the water did come under here and flow on the south side of the railroad right-of-way and then on down this way. So I would submit that there is another way for the water to go. It's not the ideal way, but if it'll go under the bridge, it will run along the south right-of-way and then down where it's supposed to. There is a defined ditch down in this area. I've been there. It's a levee ditch, and it was obviously intended for the water to go through it.
Well, while you're here, if you'll just indulge me, I tried to figure out from reading the briefs and the record where the settling basin is. Would you point that out on the diagram?
It would be right down here. Right here. And the reason it was put there was because 10 years earlier, again, the railroad had failed to keep the bridge open, and the water had nowhere to go but on the north side of the right-of-way down to this area. I would call it a self-defense mechanism because the railroad wouldn't maintain the opening, and the drainage district had to do something with the silt and debris. It failed, but that's what they tried to do.
Counsel, could you address the railroad's argument that they are not a successor to any obligations under the injunction under our Hawkeye Land decision?
Well, not only the Hawkeye Land decision, there was another decision I ran across last night. I'll try and find it here. It's the Sun Valley case. It's wording to the same effect, Your Honor. It's a 551, and I apologize, it did not get into my brief, and I designate it as an additional authority, but it's a 551 Northwest 2nd, 621. And the language in there is, we hold that Hawkeye, well, that's the Hawkeye holding. It's the holding in that case is to the same effect. If you're the successor to a real estate interest, regardless of how you get it, you're responsible to carry it out, whatever the responsibility.
That isn't really what Hawkeye says, at least. I haven't read that other case, but Hawkeye says successor and interest depends on the context, and in that case, it had to do with utility law, and there was a reason for holding that this Hawkeye land was the successor to the railroad. But here, where it's an injunction that is directed at a specific railroad, what's the basis for saying that this other railroad becomes a successor in interest just because they buy the
Your Honor, I think
line?
The gist of the Hawkeye Land case was that they succeeded to a property interest. It was a railroad crossing, if I recall correctly. And that was the tie-in between the Hawkeye Land Company and whoever their successor, I guess maybe Hawkeye Land was the successor in that case. But they got a property interest. It's the same in this case. The drainage, or the railroad in this case, succeeded to the railroad right-of-way, and the
If
obligation.
it's a property interest, then why isn't it subject to the Stale Uses Act?
I just don't think it is, Your Honor. That's a very poor answer. I think, again, we're under an injunction phase here. We're not talking about a property interest. The remedy we're trying to seek is an injunction. Under the Bear case, an injunction is a permanent injunction. It carries on forever. There's language in a case that I cited too as additional authority that parties shouldn't have to keep going back to court to enforce injunctions over and over and over again. It's repetitious litigation. In this case, the drainage district or their predecessors, this is the third time this case has been in litigation. We shouldn't have to keep doing it under an injunction.
But in this case, there's been a lot of water under the bridge, or not under the bridge.
I don't like your metaphor.
But I'm sure you made jokes about that at trial. But anyhow, there's been a lot of time elapsed since 1984, and a lot can happen geographically even in that time frame. It seems to me that the burden to proceed with a brand new lawsuit and prove up your property entitlements and your rights is not an unreasonable one to impose given the time that's elapsed.
I'm sorry, I missed your point of your questions.
I was just saying, I mean, you're talking about the difference between 1984 and 2013. That's a long time. That's 29 years. So is it really more reasonable to place the burden on you to prove up a new claim as opposed to relying on a judgment that was last seen 29 years ago, where a lot can change, and according to them, a lot has?
Well, and I would respectfully disagree. I've read the expert's report too. The things that have changed are the things that are due to the railroad failing to maintain the passage under the bridge. For one, the first recommended of the Benesh report was to restore the creek bed. What's happened, because the water's been not allowed to flow into the bridge, but flow on the north side of the right-of-way, is the creek bed is lowered 6 feet. So that's changed. But that wasn't the district's fault. That was the railroad's fault for not maintaining the bridge. The second thing he said, that if the railroad puts in a structure like the one that was present up until the time it washed out, it would fail. Probably would. It has in the past. I, again, examined Exhibit 7 through 10, which showed that for at least 70 years, there was some kind of a structure there that wasn't a super $1 million structure that turned the water under the bridge. So the things that have changed have not been on the part of the district. It's because of the railroad's actions here, Your Honor.
Thank you, Counsel.
Thank you.
Ms. Finley may present your rebuttal.
Well, a few things changed, like allowing the city to let its storm sewer run into the slough, and a lot of things have changed in the last 40 years, but that's not the issue. The issue is whether Dakota, Minnesota willfully violated the 1977 order. That's really the only issue that we petitioned for review. There may be some duties that the railroad has as the owner of the property or as a railroad under statute, but they need to be determined. Dakota, Minnesota isn't styling this document upon which the contempt action is based as a judgment. It's called judgment entry. That's what it's called. I'd also note that there have been several purchasers of this property in between Chicago, Rock Island. I think we're 4th or 5th down the list. I mean, this isn't like we just bought it from Chicago, Rock Island and took over the property.
That point actually is one that gives me pause. Maybe this is a special situation where the obligation of the railroad, not only because of the judgment that referred to this as a prescriptive easement, but because of the reality that the owner of the railroad's changed time and time and time again, and your position expects the drainage district and the landowners in it to keep coming back to litigate this over and over and over. And so there is some purchase for me in the notion that they ought not to have to do that. There was a judgment that the water goes under the bridge, and that whoever owns that bridge at the time has that obligation. So what's your reaction to that?
A couple of things. One, to be enforceable in contempt, the order has to be extremely specific and prohibit or mandate specific conduct. You know, you don't pay your child support, you're in contempt. Come within.
It's not complicated. It's pretty clear. Have the water run under the bridge. That's not ambiguous, is it? But
it may also be erroneous. I mean, let's go back again to 1913 when Chicago Rock Island came to the district court and said, we can't make this water go under the bridge. We can't do it. And they said, you're the railroad, you can do it. And then we have it in our briefs. It kept failing. They kept building it. It kept failing. They kept building it.
It strikes me you somewhat lost on that, or totally lost on that argument at trial. Let me ask you this. I mean, you say that you have kind of two lines of argument. One is that the 1977 order is not enforceable against your client, right? Mm-hmm. And then the other is it may be enforceable against my client, but we didn't willfully violate it because there were all these legitimate legal and factual questions that we raised that show that there wasn't willful non-compliance. Now, it strikes me that if hypothetically you win, it's two different things. If you win on the basis that the order is not enforceable, then they have to go back and file a brand new lawsuit, right?
Right, and there's never been any explanation for the 30-year period between 1984 and this lawsuit.
Right, I understand. Bear with me for a minute.
Okay, sorry.
But on the other hand, if you win on willful noncompliance, but nonetheless we decline to find that the order is not enforceable against your client, then they can go back on contempt again if your client is still not doing what they're supposed to do, and the order will have been clarified, and what they need to do will have been clarified, presumably, by our decision, right? Isn't that sort of a difference there?
But, I mean, again, back to the fact that contempt is the vehicle by which you punish a willful refusal to comply with a court order. Here, the first order finding that Dakota, Minnesota had a duty was the same one that found it in contempt, and we still don't know what we're required to do. I mean, in its order, they said, you're in contempt, you violated the order, now, submit a plan for what you think you're required to do. Again, the only thing we're saying here is that this is not the proper all of the errors that we have alleged on appeal could have been cured by a direct action. And I don't think it's that we're trying to say we're not trying to be cute here. When the correspondence shows the railroad was responsive. They got engineering options. They just want a comprehensive solution involving all the interested parties, including the adjacent landowners, so we're not back here litigating. Gosh, we've been litigating this forever. Everybody wants it to stop. Thanks.
Thank you as well, Ms. Finley. And again, Mr. Power, thank you. The Dakota, Minnesota case is then submitted, and we'll now hear the arguments in Central Bank.